Okay. The other issues they look at, that the employer's information, the job information, the employer-employee qualifying relationship, working at the customer location, many such issues. Let's talk about that couple of minutes if we can.
Exactly. Well, we had one case actually, Michael, and I think you and I discussed this in the past, where the consulate required the H-1B individual, the H-4 went for her visa stamp at the consulate, and then the consular official wanted the H-1B to return back to the home country to demonstrate that it was a valid H-1B and to answer questions at the consulate. Of course, that to me is extraneous and overreaching, because the question is whether or not the individual is properly married to the H-1B non-immigrant, and has nothing to do with the validity of the H-1B itself, although the consular official at that point was trying to pull the H-1B in and to sort of open up the door.
I'm saying the marriage issues out there. I can tell you that the consuls can look at whether it's really wife or not, really married or not. That part is okay.
But that's part of the
But they are revisiting the issue of H-1B of the principal applicant.
Right.
Which is, and then sometimes
it's overreaching.
Yeah, and they give sometimes a laundry list of various documents that is interesting thing. Not interesting, is a very sad thing. That I have a case just now that I'm fighting. The consul said to the wife that come and appear back with your husband in the US. They're forcing the husband to travel.
Right.
I said no. The law is very clear. Also, they were previously in some cases, they will tell the wife, show the passport of your husband with H-1B stamp. Not required. The law says it is not necessary for the husband to have an H-1B stamp. It is not required that you can force the husband to fly from US to India and appear at the consulate. Some of these things they are really doing it.
Well, I think that
not appropriate.
I think the officers by attrition are trying to see whether, I mean, of course, we're going to fight as lawyers, right?
Yes, of course.
But some of them are not going to fight, and that's what they're looking for, the people who are not going to fight.
And the last word is when there's only 1 minute left. Termination, somebody is terminating the employee, then he should properly
very important right now.
Inform the immigration service.
Very important. In this climate of DOL investigations, it's critical that they offer the individual the return transportation, they show that they've separated them from the job, and also to make sure that, that they withdraw the H-1B from the
notify the immigration service.
Exactly. Yep.
Well, we are running out of the time. We thank you very much for watching the program, and thank you, Mr. Nachman. If you have any questions, comments, or suggestions, please contact us. All our information is shown on the screen. Thank you very much, and goodbye. You guys okay, but attract us.
When did we say we're going to go to Bombay? Tomorrow night or tonight?
Well,
tomorrow, right?
My brother is coming tonight, so I'm going to discuss with him also.
Yeah. Okay, good. Does he want to go to New York tomorrow?
He has come. Huh? No, he's probably, I don't think he's going to go for hour. You're doing consultation. If you're going only for dinner, he would have come. Sure. But I'll ask him if he wants to come and join us in Shalom for dinner.
Maybe he can meet us.
Huh?
Maybe he can meet us. I'll ask Joy if she wants to meet us.
That's
Maybe
right.
I'll, and then she can pick your brother up and
Perfect.
come in.
If I'll ask him, that's perfect.
Okay, good. I'll ask her if she'll want to go.
Yeah.
I just have to see if maybe, okay,
Yeah.
maybe I can get my son to go too. That'd be good.
Very much and goodbye.
Ready?
Yeah, ready.
Clip for the,
Okay. Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Phulwani, and once again I have my partner David Nachman with me.
Hi Michael.
David, welcome.
Thank you so much.
Now we have lots of questions from our viewers. Let us take some of the important ones, and we have a lot, and if we cannot finish it, we'll continue in our forthcoming programs. So this question is coming from our own programs that we did, where we said that the cutoff dates for the employment second preference have been advancing. I have a bulletin here, let me see. In February, the second preference for India has moved by 1 year to January 1, 2010. And the employment third preference is moving very, very slowly. It moved only 1 week to August 1st, 2002. Now, big difference. People in EB2 employment second preference maybe 1 year or so. Right? EB3, the wait is going 1 year, 2 years, 7 years, 8 years, maybe more. God only knows. God only knows, unless there's a passage of the per country limit being removed and all that.
Right.
That aside.
Right.
The question that our viewer is asking, that you guys have recommended repeatedly that we should try to look into the possibility of starting another labor certification and getting into the EB2 category. But we are already 3-4 years in the line on EB3. Are we going to lose our place in the line? And my answer is no, because if the previous I-140 is approved, no.
Right, because you'll be able to recapture the earlier
old
priority date.
So that's a good news.
Yeah.
Now, this other question, follow-up question is that, again, what are the requirements for, of course, they say we have to do a new perm, the answer is yes. But then a lot of other questions that you want to address, you should address. For example, same employer, different employer, same job, different job. What are the issues? What are the concerns that they should take into consideration in doing it? Yes.
Well, I think that, matter of fact, we met with a potential client this morning, and his situation was that his employer encouraged him to do an EB3 case. And he asked us whether we should do an EB2. And we took a look at the numbers, and obviously the EB2 cases are going a lot faster, and that obviously would accrue to his benefit. So one of the things that we suggested to him was to think about doing an EB2 case, but not doing it with his current employer. Think about doing it with a different employer. And the reason why also is because what he would be able to do would be to take advantage of using the experience that he had with his current H-1B employer, which he wouldn't be able to do if he did the EB2 case with the employer that he presently had for his H-1B. So he would be able to scoop up that extra experience and use that as a basis to sort of to bulk up his case. So that gives him a much stronger EB2 case. So that's one thing to look at. If it's the same employer that's going to do the labor certification, the PERM case for him, then what we want to do is probably think about doing it in a completely different occupational classification. So that would be something
basically
else
what
to
are the
look
requirements in terms of education, experience, because EB3 they got approved. So they made the requirement of whatever bachelor's degree and some experience they had. But EB2 more than that, if you have different requirements, and how can they meet? And one of the, that's a good thing, that the example you gave, in order to meet that requirement, by doing that, using the experience gained with the EB3 previous employer, they can now utilize that. If there's a requirement of a bachelor's plus 5 years, that 5-year experience has to come from the previous employer, unless the job is different.
from the previous employer, exactly.
It's
right.
easy to do that, but same employer, then he has to show the different position. It's a little bit of that's on a microscope. I mean, those kind of cases, they look in microscope that this employer just trying to do it just for the sake of helping him, or is it real? So,
well, I think that the problem that I find when I sit with clients or potential clients is that they don't understand the logic behind that when I say, well, think about possibly doing an EB2 case through another employer. And they say, why in the world would we do an EB2 case with another employer? Why would another employer, let's say an employer out in California or an employer in Texas, do an EB2 case for me if I'm working in H-1B status for employer number 1? Why would employer number 2 do the case? Well, the thing that people have to understand is that the green card process is prospective in nature. It doesn't have to do with what's going on now. It has to do with what's going to happen in the future, what that individual will be doing when they receive the green card. So you could have several green card applications going for you. It doesn't have to be one green card application. So you can pursue as many opportunities as there are that exist for you.
What you said just also relates to compensation. Now here it is. Employer is paying him $47,000 on a H-1B, and same amount of he has made in the EB3 application. And he says, okay, I'll do EB2 for you. And you call the employer, say, but for this job, your salary has to be at least $82,000. Because it's a master's degree, it's a bachelor's plus 5.
Right.
I don't want to pay him 82. And you will say, oh, you don't have to pay him 82.
That's exactly right. You don't have to pay it.
Just on the offer that what you are saying, Mr. Employer, that when he gets his immigrant visa under the EB2, and starts that job, which is mentioned, then only you have to pay 82.
That's correct. However, also you have to remember, and I know that you know this, Michael, as we do painfully, is that in the process, the employer is required to demonstrate, and usually this comes in an RFE after the I-140 has been filed, the employer has to prove the ability to pay the federally mandated prevailing wage. So while the employer has an interest, of course, in trying to bring that amount of money that they make at the end of the year down, what could potentially happen is the employer, by doing that, could potentially jeopardize the viability of that PERM labor certification for the applicant.
That is correct. So all these issues have to be taken into consideration
from the beginning. From the beginning, Michael, it's very important that an employer and an employee together consult with a qualified legal professional to ensure that each one of these issues is addressed prior to receiving that RFE, because we receive so many of these.
Isn't it like marriage, that prior to getting married, you should look at everything, the background of the wife, background, the education, experience, knowledge, compatibility, whether you want to spend the rest of your life together happily ever after with
exactly.
Then just getting married, any woman, and then trying to figure out, oh my God.
Right. Check under the hood before you buy the car. Right?
Right.
Exactly. Do it up front.
Exactly.
Don't wait until you get the RFE, because it's very difficult to go back and start amending your tax returns.
Let's move on to another question from one of our viewers. This guy came from UK on a visa waiver. No, there are some countries which are approved on a visa waiver program. They don't need a visa, and they can just come to United States to visit for 90 days.
Right.
So this client did not get a visa. They just come on visa waiver, and the immigration admitted him for 90 days. And the law says you cannot just change status or work under that.
Right. They can't change their status or extend their
status. For a long period of time, cases like this happen, that the visa waiver person got married to a U.S. citizen. After the 90 days expired, because the law says that you could apply for a green card. But their position was different. And some period of time in between, it was working, and then again, the Immigration Service took a position that if you have overstayed, then you cannot adjust the status in the U.S. They were back and forth for a long period of time. Now this matter has now finally settled down. Right. And the settled down is?
Well, at this point in time, what they're doing is they're saying that individuals who entered on the visa waiver program did in fact make a bona fide entry for the purposes of being able to adjust their status in the United States. And that, Michael, as you properly pointed out, has to do with what's called the Bradley case. And for several months, we wrestled with a dichotomy between the New Jersey and the New York district offices that were handling this in a different manner. In New York, they were allowing people who came in, who entered on a visa waiver and who overstayed to adjust their status at the district office, whereas New Jersey put these cases into an administrative hold pattern. However, at this point, we can report the favorable determination that now they're allowing these cases to go through.
It took some time, a longer time, for the headquarters of the Immigration Service to make a decision and have a policy that is implemented nationwide in the U.S. by all the immigration officers. That's what has happened. Now it is okay. If the visa waiver person is here who came legally, entered legally, overstayed even by 1 year, now he gets married to a U.S. citizen, we can apply for adjustment of his status without much problem.
That's right. And Michael, I'd like to point out an issue which we had actually with a client many, many years ago, although we haven't seen it recently, is if you do enter on a visa waiver, and you do decide that you're going to marry a U.S. citizen, you also have to be very careful of the 30-60-day fraud rule. Because if you made an entry and you file that adjustment of status within 30-60 days, you could be potentially putting yourself in a position where the government can argue that you made an illegal or a fraudulent entry for the purposes of that marriage.
Actually, this is the reason, I believe, that many times these visa waiver people came in and did not get married because they are only 90 days. So they did not immediately get married within a month or two, because somebody advised them that a quick marriage after the entry will cause the fraud problem. So that's why this issue came in. Most of the marriages were happening after 4, 5, 6 months after the entry, so that the fraud issue doesn't come in. But then the other problem came and hit them, and they said, no, you are overstayed, you cannot do. But again, this matter is finally settled, now no longer a problem. As I said earlier, you came on a visa waiver, you are in the US, you get married even after 1 year, it's okay, right?
Right.
Good news.
Right. And Michael, now that we're talking about visa waiver, I think this is an excellent opportunity for us to just make our viewers aware that the Obama administration has issued a presidential order which has to do with the liberalization of visitors to the United States recently. And it seems that what the Obama administration now is doing is trying to loosen up some of these visitor rules. And it seems like what we may see, hopefully in the future, in the near future, will be additional visa waiver countries being designated by the Attorney General.
And that memo also talks about the expanding tourism and inviting more people to come to visit US or students to come to US and all that. It's an executive order of President Obama.
Right.
And it's very good. And let me
It's excellent news, Michael. What visitor do you know that comes from abroad who doesn't go on a shopping spree on Fifth Avenue, right?
Absolutely. So they spend a lot of money.
So it's very good financially for our country.
Let me share some secret with you, which will no longer be a secret once we say that on the television. Last week when I saw the memo, I got a little upset that the consular officers were still not looking in the same spirit at Obama administration. So I prepared a 3-page, 4-page, after my 2 usual glasses of wine, I sat down and prepared a very nice 3-page representation to the Obama administration that this is very good, but you should just have clear guidelines to the consular post, the Department of State, or the Homeland Security, to implement these things. Sometimes they issue a memo, nothing happens, and there's no good. It's just for the publicity only. So hopefully I'm saying even our Immigration Lawyers Association will do some representation and put a little pressure on the administration to implement them, so that more and more people can get the visa without much problem, come and visit US and spend money and have fun, meet their parents, grandparents, children. I mean, what is there? Basically, their whole approach has been wrong because of Section 214B. We did cover at length in our previous programs. So hopefully that there is something done. Okay, this other question is from a US citizen whose brother has applied for visitor visa to visit him 2-3 times. Every time denied because your brother is a citizen. Sometimes the consul go also into that if a brother is a citizen or somebody, they ask him a question. How did your brother go to US? He say he went on a student visa. So then he changed the green card and so your brother came on a student visa and he did, changed and became a citizen, and you want to go on a student visa. Let's say, why don't we say that you brought the same thing? Exactly. Going back, let's say 10 years ago, 15 years ago, and nobody really knows. The circumstances in each case are different. Brother had an opportunity, he did not come with that intent. There was a change in the circumstances and he became a citizen. Anyway, so his question is that now that he has graduated, he has a master's degree, and there's an employer willing to offer him a job and file an H-1B petition. But he's worried that because of the 3 previous denials, the consul may deny him H-1B visa. Your comments?
Well, the consul, of course, has the ultimate control, and they can make that determination. However, because it's a dual intent visa, they should not. So that's where we would come from. If they did decide to deny it, of course, I think we would be able to challenge it through the appropriate channels, one being directly to the consulate, and 2, ultimately having resort to LegalNet.
The only important thing is to remember is that consul cannot deny because of the dual intent. But if somebody in the previous visitor visa, student visa application gave wrong information, misrepresented the facts, lied something, the consul is going to say, forget the dual intent, you committed a fraud, misrepresentation previously, so we are going to deny visa to you not only today, but for the next 99 years. I don't know whether they get, because they don't think that you're going to survive. It's a lifetime bar, but the consuls, I always see many times, they say, for 99 years, you got a bar. So it's very, very important that if you have previously applied, make sure you did not commit any misrepresentation. Then you have a fairly good chance of getting an H-1B visa from the American consulates. I think we are running out of time, David. And we thank you very much for watching the program. If you have any questions, comments, suggestions, you need your assistance, please feel free to contact us. Our names, addresses, everything shown on the screen. We will try to do our best to inform you of whatever questions, reply to you that would be of help to you. So please keep watching us on ITV every weekend, and you get more and more valuable information on this program. Thank you very much and goodbye. Only one? No. Only one. And closing. हेलो, हमारे सभी दर्शकों को माइकल फुलवानी का नमस्कार, आदाब, सत श्री अकाल। तो आज के इस प्रोग्राम में फिर हमारे साथ हैं हमारे पार्टनर मिस्टर डेविड नाकमन। नाकमन जी, वेलकम।
Thank you. Namaste, adab, sat shri akal.
Thank you, thank you. But David, you have to learn much more Hindi and Urdu than this, because this is supposed to be a Hindi program, and we should slowly do this more in Hindi. But for today at least, or maybe for next few programs, we're going to be continuing our talk in English. and we hope that you'll find this information very helpful. If you have any questions, comments, you can always be happy to respond to your, जो भी आपको सवाल हो आप हमसे पूछ सकते हैं. Closing, yeah. तो अब आगे और समय नहीं है आज हमारे पास. हमें ये पूरी उम्मीद है कि आपको ये प्रोग्राम काफ़ी हेल्पफुल रहेगा. अगर आपको कोई भी सवाल हो, सुझाव हो, तो आप हमें कांटेक्ट कर सकते हैं. हमारी एड्रेस, ईमेल एड्रेस, वेबसाइट, टेलीफोन नंबर सब स्क्रीन पर बताया गया है. और आपको कोई भी हेल्प चाहिए, असिस्टेंस चाहिए, सवाल है, तो आप हमें कांटेक्ट कर सकते हैं. हम पूरी कोशिश करेंगे आपको हेल्प करने की. बहुत बहुत शुक्रिया. थैंक यू वेरी मच एंड गुड बाय.